You are way too quiet. Wow. Hopefully you're saving all of your energy. Well, welcome back. Welcome back. Hope you had a good week. Let's see. I think just about everyone's here. I think about 2 people.
PJ's stuck in traffic. She just texted me. She's trying to get out of her work garage, so she's right here.
Jordan just texted me, said Travis wanted him.
Okay, well, we will.
Nobody texted me because
No
I
one.
have no friends.
That makes sense. You open the door to that one. All right, so welcome back, everyone. Hope everyone's doing well, and I've spoken with a number of you about your papers. I'm glad you're starting to think about it. Today, our focus begins really with the separation of powers, with what I think is probably the most important case of the 20th century, and I don't put that lightly, which is, of course, Youngstown G and Tube Company versus Sawyer. And I'm sure you all studied this in Conlaw. This was the famous steel seizure case. This was the case where, at the height of the Korean War, there was a labor crisis. And the steel workers could not get along with the management, and they determined to go on strike. President Truman determined that it was not feasible for the strike to happen because it would impact the war effort in Korea. Troops would die, he said. So he decided to do something himself. He issued an executive order, Executive Order 10340, which ordered Charles Sawyer, that's the Sawyer, to seize the steel mills and put them under federal control. Not only that, and this is the part which is not in the case, but which is known, is if any employee tried to go on strike while the steel mills were seized, they'll be arrested and thrown in prison. Not only that, this also wasn't mentioned in the case, but now the steel mill would be under the direction of the United States government. And guess where their priorities would lie? Guess what they'd have to make? Guess who would be the first one to get all the steel? There was no payment made for this. There's no provision for payment to be made. And this seizure would last as long as the government deemed necessary. This case represents so many separation of powers violations, it's hard to tick them off. So in this class, even before we get to Justice Jackson, now resolved it, I want to discuss each and every single separation of powers violation in this case. And there are a lot of them, right? All right, so let's start. Who wants to go first? Yeah, you raise your hand? So what's the first separation of powers violation you see here? Present lawmaking. Okay, why is this lawmaking?
He's basically infringing upon one of the powers in Article 1 given to Congress as far as that's something they can control.
Which Article 1 power are we talking about? Get your Constitution out. You have it. Which Article 1 power did the President violate here? Or precisely, which Article 1 power are we talking about?
Section 1, Article 1.
Okay.
All legislative powers here granted shall be vested in Congress.
Okay. So we know from the very first sentence of Article 1 that Congress has the lawmaking powers. But Hugo, you didn't answer your own question. Why is this lawmaking? He issued an executive order, right? What's an executive order? Anyone? Raise your hands. What's an executive order? Colin, what's an executive order?
Well, almost like an exception, a new law, a new.
Is an executive order law?
Temporary, yeah.
Well, what do you mean temporary?
Well, in this case, because of an emergency.
What's the longest an executive power order could last? There's an answer.
It can be voted on and last, like the Congress can vote on it. And it lasts forever.
What's the longest an executive power could last?
Forever.
Is it forever?
Is that 60 days?
No, I think you think of the War Powers Resolution. Think about this. The President issues an executive order. What's the only way that executive order gets repealed? Not Congress.
The challenging Supreme Court.
Not the Supreme Court. Think.
20 days. to
Veto?
do it.
The next president. Oh, right.
So it could be 4 years, 8 years.
4 to 8 years, right? An executive order, someone says a law. It's not really a law. It's the president asserting that his own powers allow him to do something. But that is only valid so long as he's in office. Because on January 20th of the following year, when the next president comes in, he repeals the executive orders. In fact, that's very common. On President Obama's first day, he repealed dozens of executive orders from Bush. This happens every time.
It was just as a side, but Saturday Night Live did a really funny skit. Like they did the
Yeah.
I'm just a bill, and then they kicked him down.
Yeah, right. So what is an executive order? So it's not a law. It's not a bill. The president's merely exercising executive power. So let's break this down very carefully. Hugo said correctly that Article 1, Section 1 says all legislative powers herein granted. What makes this executive order? Executive order, I have it up here, 10340. This is it. What makes Executive Order 10340 a law? Eddie, what do you think? What makes Executive Order 10340 lawmaking? I think Hugo's right, but why is this Executive Order lawmaking? What makes something a law?
Would it be within the president's authority to act in that fashion because of the circumstance or the context, the emergencies?
You're like a couple steps ahead. I want the more fundamental question. What makes something a law that will be passed by Congress? What's the difference between the president's actions and the Congress and the actions? Hugo, want to try it?
Enforcing it?
Ooh, okay. So everyone, turn in your constitutions, right? Article 2, Section 3. It's on page, Article 2, Section 3. It's on page 31, okay? And you see it says in that paragraph, he shall take care that the laws be faithfully executed. So Hugo said correctly, Article 1, Section 1 says very clearly, all legislative powers herein granted. So Congress has all these legislative powers. The president's duty is defined here. He shall take care that the laws are faithfully executed. Right? So here we have this parallel, right? On the one hand, you have the Congress which enacts the laws, and then you have, like you learned in the first grade or whatever, right? The president executes the laws. So I'll ask again. Let's see. Ian, what does it mean for the president to make a law? How is it that the president makes a law? Why is this executive order a law?
Is this from an act of Congress or from the Constitution itself?
Is this executive order a law?
No.
Why not? How do you judge if something's an executive order or a law? What makes it lawmaking? I think Hugo's right. He said this lawmaking. What makes this lawmaking?
I guess he would be setting policy.
Ooh, okay, policy. We're on the right track. Dad, what do you think?
Also usually the law or the bill go from Congress to the president, but if he issued an executive order and Congress doesn't pass anything to review it by default is a law.
Interesting. So what I think both of you are saying is you have to judge it based on what Congress would have done, right? So I think one way of looking at it is this something that Congress could have done, right? If this exact executive order, word for word, came not from the president but came from Congress, would everyone agree that that's a law? Yeah, I think everyone agrees that's a law. So it's somewhat circular then, right? What makes something a law is it's the type of thing that Congress would do. It's not a very satisfying definition, right? But what makes something a law is basically something that Congress can do. If it's within the lawmaking powers of Congress, then this executive action is a law. And as a law, it has to come from Congress. Everyone see that? Now, oh, it's not Robert. What do you go by? I'm sorry. Mike, I'm sorry. I don't have a pen. I'll probably put your mic. Mike, so let me ask you a follow-up question, right? So say Congress had passed that law, right? I got Sharpie, right? Mike, say Congress had passed that law, the exact same thing. Could Congress have passed that law?
I don't think they would have.
No, don't ask would have. Could they have?
No,
Why not?
because they have to provide just compensation for it.
Good. Okay. Even if Congress wanted to pass this law, they would need to provide just compensation. Why is there compensation needed? Which constitutional requirement are we talking about? Going to my other class, which some of you had before?
Well, government can't take any property or anything.
Which,
without just-
give me an amendment number.
I don't remember.
Zach?
off the top of my head.
5, the takings clause, right? So Zach, read the takings clause if you got your constitution handy. It's on page 44.
I don't have that.
Oh, okay, Mike, just read the takings clause. You already had that one on page 44, Fifth Amendment. It's the very last clause of the Fifth Amendment. I'm about to blow your minds with this one. Wait for it. The last sentence of the Fifth Amendment.
Nor shall private property be taken for public use without just compensation.
Right, okay. So this provision, if this exact executive order had been passed through Congress, you're right, Congress would have to provide just compensation because they're taking this property. All right, so now, where does it say in the Fifth Amendment that's Congress who gets to decide whether to take property? Oh. Does it say anywhere in the Fifth Amendment that Congress is the one who gets to decide which property to take? Whoa. So I'm gonna blow your mind one more time after this. I'm not done yet. Why is it that the Supreme Court and Justice Douglas's concurring opinion in particular, right? Why is it the Supreme Court so convinced that it's Congress who decides whether they can take property? Why can't it says here, Mike read it 5 seconds ago, nor shall private property be taken. It doesn't say anything about Congress. Go to the First Amendment, right? Congress shall make no law. And that's clear. Here it doesn't say anything. Anyone want to take a stab at this? Why from the Constitution do we understand that only Congress has the power of eminent domain? Yeah.
Guess it's because Congress has the power of the purse.
Yes. Explain more. You're exactly right.
Because they have certain enumerated powers to levy taxes and all that stuff. So then I guess from there it makes sense that they would be able to.
Exactly. Who else is going to pay the just compensation? Does the president have the power to raise taxes? Can the president withdraw money from the treasury? Okay, so this is the first one, right? It only makes sense for the legislature to have the power of eminent domain because no one else can pay the compensation. Okay? So this part, this one's going to blow your mind. Why the heck does the federal government have the power to take property in Ohio? What gives the federal government the power to condemn and take property that's not in a federal park or the District of Columbia? Where do they get this power from? Oh,
Is it from the housing?
what do you mean housing?
Well, I mean, they gave people like the, once they go back to like the militia when they would just like let people stay in their.
Is there like the Third Amendment quartering of troops?
Yeah, I heard that.
That was mentioned. Where does the federal government get the power to take property that's not in federal land? So here's the answer that none of you probably ever thought about and like no one thinks about. There's no actual federal eminent domain power for land in the states. A good friend, Will Bode, who's a teacher at Chicago, wrote this article, which blew my mind. I never thought about it. There's no power in the Constitution for Congress to take private property in the states. This leads into the second case I signed for today. How do you think Congress has the power to seize property in the states, Zach? Necessary and proper. You see, there's no direct power of Congress to take property, right? But perhaps pursuant to Congress's war-making powers, or maybe their powers to raise and support armies, right? Congress has the power to raise and support armies. They can take private property in times of war with compensation. Everyone see this? Everyone with me so far? Now, one more layer blowing your mind. Now, some of you studied the Obamacare case, but probably not closely enough. We'll do it a lot more later, okay? Necessary and proper. Two things. In McCullough, the Chief Justice Marshall only focused on necessary, right? He kept saying, is this convenient? That's how we define necessity, right? Is this convenient? So I think it's safe to say it's convenient for the government to take property for the war efforts, but is it proper? And what the court said in NFIB, this is the Obamacare case, that necessary and proper are two different things. And something can be necessary, but not proper. So let me ask you this question again. And this, there's no good answer. I only thought of this afternoon while I was preparing for class. Is it proper for Congress to seize nationwide steel mills indefinitely, put them under federal surveillance, and threaten to arrest anyone who decides to walk off the job? Anyone? Kelsey, what do you think? Is it proper for the government to seize nationwide steel mills across the country and basically put employees under federal supervision and arrest anyone who walks off the job? Do you think that's a proper exercise of federal power in our constitutional order? Why not?
They're overreaching.
Overreaching? What do you mean overreaching?
They're taking too much power into their hands.
Ah, I think you're right. Anyone else want to add to that?
It might not be proper if you could achieve the same thing by a lesser means.
Ooh.
So there's no need to seize it if you just set price and wage controls.
Ah.
Intrusive act.
Right. So I think you're both right. Even if this is convenient to Congress, it's not necessarily a proper exercise of federal power, because it's kind of dictatorial for the government to just seize an entire industry for some indeterminate period of time and basically threaten to put in jail anyone who disagrees with the order. Okay, so I think the first aspect of this case, which isn't really addressed much, is the underlying act itself. Not just that Truman was making law, which I think Hugo's correct in saying that he was, that this executive order resembles some sort of policy as a law. But more importantly, what was the law he was making? He was effectively taking over an entire industry. And this is something which Justice Douglas says could be done. I don't think could be done in the federal Constitution. Congress couldn't have done this either. I think there's a very good reason why. You know, we talk about a case like Kilo, where they want to take a piece of property to develop into something better, you know, research facility, whatever they want to do with it, right? Even there, they're giving people compensation, and they're actually letting people have time to go through the process. Here, they're just taking the steel mill and then basically locking people up who don't agree with it. So there's a decent argument that even under McCullough, that this would not be valid. Okay? Any questions on that? This case is really deep. We're going to keep going deeper. Okay? What's another serious separation of powers violation in Youngstown? So Hugo said correctly the lawmaking power. What else is there? Let's see. PJ, what do you think? What's another separation of powers violation attending Youngstown beyond the lawmaking?
Trying to remember. Separation of powers.
Hmm? If there's a number of them. What's another biggie?
Well, they.
Let me ask you this, PJ. Did President Truman go to Congress first before he took the mills?
No, he didn't.
What happened? What was the sequence of events?
He had the forget, was it like the Attorney General or
Secretary of Commerce, right?
yes, go and just seize the mill.
Right. And did Truman send any communications to Congress about this?
No.
Well, he did.
But it was just kind of like he was just telling them.
Yes.
how to do it.
Exactly. Exactly right. So shortly after Truman sent his Secretary of Commerce to take over the steel mills, he sent a note to Congress. Did that note PJ asked for any permission? No. The note basically said, hey guys, look what I did. He didn't ask for permission. What did he ask for, though? Yeah, Colin.
So I was just gonna say, I didn't realize, or maybe the last time that we studied this case, I didn't realize that they had refused to accept or adopt this previously.
Well, we'll get to that in a few minutes. That's my third one. But I promise, come back. When I say my next one, I'll call on you, okay? But let's say this one for a second, right? What did Truman write in his letter to Congress? He didn't ask for permission. What did he say in this memo to Congress? George, you got it?
Me?
Yeah.
Yeah, what he said to Congress?
Yeah, what did he actually say in his letter to Congress? Anyone got it? He didn't ask for permission.
Can you just tell them to support him?
Pretty much.
Yeah.
What he basically said in his letter to Congress was that if you guys want to support me, if you want to pass some bill supporting me, I'll accept that. But if you don't, too bad. Okay? So what is the problem here? Gwen, what's the separation of powers issue here? Where the president does this, doesn't ask for permission. In Washington, D.C. is an expression. It's better to ask for forgiveness than permission. And this is a good example of it. What do we make of this when the president basically asks for saying, hey, if you guys want to support me, fine, but if not, too bad. What do we make of that?
Kind of going against what the Constitution stands for.
Be more precise. How does this act treat Congress? How does this act reflect on Congress?
Like, you don't really need Congress. The president can just do whatever he
I
wants.
like-
It's not being checked.
Good. Basically what Truman's, Eddie, you ever think that?
Seems to treat the rest of them like his lapdog.
Oh, I like that, lapdog. Yeah, expand. I think you're on the right track.
He's just dictating to them to get in line and to support him regardless, it seems. He's not
Basically.
asking, he's kind of
He's not asking, he's telling.
disempowering them.
Okay, I like that.
There's a reason that Congress is the one that should be part of that.
What's the reason?
I guess maybe it has to do with that they're elected by
Yes.
people.
Well, the president's also elected,
Yeah.
and the president was elected by nationwide. And for the president's the only office that has a nationwide electorate, which is somewhat unique. But I think you're both on the right track. Truman's basically saying, I don't need you guys, right? I don't need you. I don't need you because I'm going to do this myself. I'm going to take care of this on my own. And the image of the lapdog is appropriate because if the Constitution imposes these strict checks and balances, the president's simply disregarding these, right? So let's put yourself in the member of Congress, right? Let's see. So Lacey, let's say you're a member of Congress, right? You're a senator from Texas, whatever, in 1952. And the president sends this letter to the Congress and you see it. What's your reaction going to be?
It's incredibly arrogant.
You can be mad, right? So what do you think if you were a member of Congress, what would you do about it? Lacey, what do you think?
Sorry.
Senator Lacey, what would you do?
I want to impeach him.
Well,
Get him out of there.
Short of impeachment,
Do that.
short of impeachment, what would you do immediately? The president sends us a letter saying, I'm going to seize these steel mills. I don't really care what you think. You can pass law supporting me, which would be nice, but if you don't, whatever.
Start taking the appropriate steps to get rid of him.
What are those appropriate steps? Short of impeachment, short of courts, Congress.
Can I veto or just, I don't know.
Well, what are they going to veto? It's an executive order. You can't veto an executive order.
Pass something.
Okay, you said something.
He's not gonna fund the people to go and
Okay,
watch them.
okay. So what would what would that entail? Think about it.
I mean, I guess in a broad perspective, they're gonna have to pay someone to go and actually seize that steel mill and pay the police or whoever is
Exactly.
arresting everyone.
Right. So Congress has the power of the purse, right? They can defund stuff. They can say, we will not allocate a single penny to the Secretary of Commerce to seize this mill. No federal employees can earn a dime by actually enforcing this. And there's a basic law that says the president can't spend money without any appropriation. And appropriation is basically allocating money. So yeah, so Congress could say, we're gonna defund the Secretary of Commerce. Now, this is going on within 24 hours. Okay? Congress usually budgets a year or two out, maybe not now, but in general, right? Congress usually budgets a year or two out, right? So there's no possibility for Congress to actually pass a budget within the next 72 hours to fund this because they've already done it. So what other options could Congress do? So Senator Hugo, what do you do? You're in the Senate. You get this letter, says we don't give a damn. So you're a member of Congress. What can you do in a short time frame? Think about it. What can Congress do in this situation? They can't. The funding is not practical. Impeachment will take too long.
Call the president and tell him to hold on.
Do you think you'll listen? He already told you to F off. I mean, he already told you, I don't care. This letter was a Missouri middle finger from President Truman. Lauren?
Can you get rid of the Secretary of Commerce? Like
Ooh. Under the Constitution, can Congress remove officers? No.
Well, they could, but they have to okay his.
Yeah, so unless the Secretary of Commerce dies, you know, maybe if they kill the Secretary of Commerce and put a new one in, I guess that works, right? Right. There's no power of removal from Congress. Chris?
I was going to say, introduce a bill that would make what the president's doing completely
Illegal.
illegal.
What would that bill look like? That's a good answer. What would that bill look like? I'll get there. What would that bill look like?
Basically saying something like, president cannot go ahead and seize property.
Yeah. So okay. So say both houses of Congress, with majority vote, pass a bill saying it's our sense that the president lacks the power to do this, and only Congress can do this, right? Lauren, what would Truman do?
Veto it.
He'd veto it. So think about that for a second. Congress as a body is expressing, and we'll get to Jackson a little bit later, but think of Jackson for a moment, right? Congress as a body is trying to limit the president's power according to the Constitution. And what does the president do? He vetoes it. Zach?
See, that would still take 10 days at least, because the president has that much time. I mean, couldn't
He
Congress
can run it out.
threaten not to fund the war effort anymore?
Okay, that's another option, Zach. Congress says, you know what? We are going to stop funding the troops in Korea. What happens then? How do they get home? If there's no planes to fly them home, they stuck in the DMZ. I mean, if there's no money to put gas in their engines, are they just going to stop? But I'm asking seriously. It's often said Congress is the power of the purse. Can you imagine any circumstance where you defund troops who are getting shot at? Where you say, whoops, no more gasoline for planes to bring them home. Sorry. Right? No more. We're not sending any more meals for them to eat. We can't ship any more meals there. They'll have to forage. Right? It's not. It's a serious thought. I appreciate that, but it's not happening. Is that hand? Yeah.
Could you sue them and join the action?
Let's not get the lawsuits yet. But we'll ask about lawsuits in a minute. What other? Yeah.
Just, it has no effect of law, but they could pass a sense of the House or
Exactly.
Senate.
A resolution.
At least be on record
Okay.
for the whatever comes after that they don't feel that this action is legal.
Okay. That was actually what I was thinking. That'd be my ideal choice, right? Congress would pass a resolution saying it's the sense of the House and the Senate that this action is unlawful. Jason, what would the purpose be? I think it does have a purpose. What would the purpose be?
Well, the purpose would be, number one, to raise the profile of what the president was doing, that the action was strange, unusual, and unprecedented.
Good word.
And and that and like I said, to be on record for any lawsuit or thing that would follow.
Let's go to the lawsuit. Okay. So you were about 20 seconds ahead of schedule. So I'll come back to the other one later. What about a lawsuit? Who? First of all, this lawsuit was brought by steel mill owners, right? But let's put aside for the moment that you're a senator, you're a member of Congress. Could you bring a lawsuit to challenge the president's action?
Isn't that what Boehner just tried to say?
I think you see what I'm getting at. Could Congress bring a lawsuit challenging the president's lawmaking?
It would come down to standing.
Oh, standing. So this was not in your reading, so I'll give you a little bit of a summary. So over the summer, the House of Representatives voted as a body to bring a lawsuit challenging the president's decision to basically not implement various aspects of Obamacare. And a lawsuit was brought in federal court a couple months ago. The standing in this case is very difficult because, as you know, for standing, you have to assert an injury. How are members of Congress injured when the president ignores the law? Does it?
Voters.
What?
Injures them from voters. Like if,
Oh, explain.
like, I mean, if,
You're
I
on.
guess if you're, say you're a Democrat and, you know, you're representing, you know, your area or whatever, and, or your state, and, you know, you're saying, you know, yes, I'm the same political party as him, but I don't agree with Obamacare. So that's gonna hurt me as a, like, at getting votes because.
That's actually one of the arguments being made that I don't think is going to work. So actually, Senator Ron Johnson is a Republican from Wisconsin, sued the government. Okay, what happened? So originally, Obamacare was designed that members of Capitol Hill, people who work for the government, were required to basically buy Obamacare. They couldn't get all the subsidized, cushy benefits other federal employees got. This was unpopular because people in the government like getting their cushy benefits. So basically, the administration rewrote the law. They said, you know what? We'll give you benefits even though the law said you can't have them. So a member of Congress, Ron Johnson, sued saying, this impacts my credibility with my voters. I'm on record opposing Obamacare, and now my employees get it. How does this make me look? So actually, that case was argued at the 7th Circuit yesterday, and I think they're going to lose. But that's one option, right? So the idea of the House of Representatives suing, I don't think it's going to work. It's a very, there's only one Supreme Court case on point which says that if the legislative power has been nullified, you can sue as a body, but I think it's a real stretch. I don't think it's going to work.
I think they should try to be, like, if they're that upset with everything.
Okay, so let's talk about impeachment, right? This is the check which has never really been used unless she's been dallying with an intern, right? Middle of the Korean War, chief executive, bring articles of impeachment. How do you think that would go? Lauren, what do you think?
I mean, it's not gonna go well, but I was talking about in current cases.
Okay, yeah, well, we'll get to Obamacare later, I promise.
The man who dropped the bomb. You're gonna.
He dropped, yeah. You're gonna impeach the man who just dropped 2 nuclear bombs and is leading another war against Korea, an undeclared war, might I add. If you notice, Justice Jackson and Justice Frankfurter made these little snide comments saying, "Oh, by the way to make war is through declaration. There's no declaration here." Anyone know what the basis of this war was? It's mentioned in dissent.
Was it United Nations?
Basically, so here's the argument: the Senate ratified to join the United Nations. And the United Nations said, you know what, we need to provide support to Korea. So in pursuance to our duties to the UN, Truman led us into war in Korea. Since World War II, there's not been a declared war anywhere in the world. Hasn't happened. Right? So we go back to the lawsuit, right? Actually, we'll do the lawsuit in a minute. Colin, what's another way that this law violates the separation of powers? You said a couple minutes ago.
The Taft-Hartley Act
Good.
has been under consideration first, and Congress rejected the amendment that would make the times of emergency, the governmental seizures, not authorized in times of emergency. So he had already kind of asked for permission.
And what did Congress say? No. No means no, right? So basically, we kind of jumped the gun a little bit. But Congress had already spoken to this issue. And let's think about the timing, right? The Taft-Hartley Act was 1947. This is what, 2 or 3 years after the end of World War II, right? We had just nuked another country. We had had all these labor strikes. We had all these nationalization movements across the world. And Congress was very familiar with what war was. They knew how war worked. And they're very familiar that during times of war, sometimes industry will want to go on strike, and you need planes, you need bombers, you need bullets and everything else. Congress considered the circumstance where the president might have to have exercising power to seize a steel mill or seize any industry. And Colin, what did Congress say to that? Did they want to give that power?
No.
The answer is no. So Congress spoke directly to this issue, right? They spoke directly to the issue. Was it 4 or 5 years ahead of time? They said to the president, no, we will not give you this power. So what is the separation of powers violation at issue, right? How is this a violation of separation of powers? What do you think, Eddie? How is this law passed 5 years before, which denies the executive this power? How is that itself a separation of powers violation? What's going on there?
Are you saying with regard to Congress violating the separation?
No, to the president.
With regard to the president. It seems as though it's just they've already expressed their disapproval that they're not, and that this is flaunting his authority or pseudo authority. Yeah. Is that answering?
What? Yeah, but let me ask a follow up to this. What about the fact that after the president did it, Congress stayed silent? What do we make of that? In other words, if Congress spoke to this issue in 1947, the president took the steel mills. They stayed silent, didn't do anything, didn't impeach him, didn't do anything.
It would look as though, I guess, that was implicit in some fashion.
The word I like is acquiescence, but complicit's good too. Ever know what acquiescence means? Like they're giving in. Did Congress acquiesce to this by remaining silent? As Lacey and Lauren, what would they do? They're impeaching him, throwing him to the wolves, right? But these senators are a little bit more circumspect.
I think they were kind of watch and wait. Like, let's see.
Watch and wait.
Like,
okay.
but like he just did this order. Now let's see what let's see what he's gonna have any putting backbone behind it, because he can stand up there all day and make an order, and whether he's gonna go down there, I think it was a watch and wait.
Anyone else? What do you think? What do we make of the fact that Congress did nothing?
Well, doesn't that kind of set a precedent for things to come as well? Because that's not. I mean, I just feel like that's not a very good idea, because
To stay silent.
Right, just because in the future they're going to use that for another. We did it before and it was.
Well, why do you think? Yeah, Hugo. Why? What do you think?
The question is, why did Congress do nothing?
Yeah, why do you think Congress stayed silent? They didn't do anything. They didn't say yes. They didn't say no. They didn't file articles of impeachment. They didn't do anything.
Somebody's, I guess, the corporations, as soon as, I guess if they deny it, they're going to be in China to bring suit themselves.
Oh, so you think that Congress was relying on Congress to fix the courts to fix this mess?
Yeah.
Oh, I wouldn't be so sure. This case was a shot in the dark. What do you think? Why do you think Congress stayed silent?
You're in a war, and you want to appear united. You
Ah.
have to go against what the president says, and you already got it.
So, did Congress actually oppose this then? You just said they want to see them united. So, did Congress actually find this was a violation of separation of powers? Ooh. What do you think, Dad? Did Congress actually oppose this? If they said nothing, did they actually have a problem with this?
Which is implied. Usually, if there's something that's against your will and you don't like it, and if you just stay quiet, the imply is
You accept it.
you accept it.
You accept it. Exactly. So, is it so crazy for the president to argue to the Supreme Court that, listen, yeah, they passed the statute 5 years ago, but they didn't do anything about this. They acquiesced. They gave in. What's the response to that? Chelsea, what do you think? What's the response to that? How would you respond to that? You're a lawyer for the steel mills, right? President Truman says, listen, they could have said something. They didn't say a damn thing. They were quiet. How do you turn from that?
I mean, I was just thinking that maybe Congress stayed quiet because they realized that the president wasn't able to do this on his own, because they would have all these big steel mills on their side. So they would also need other people to go in there and function and do whatever the president was trying to do, but he wouldn't have the people.
So so Congress thought he couldn't actually pull this off. It's not going to work. Is that what you're saying?
Without their support and their backing.
Well, he did it himself. Congress didn't support him. There were already troops in the mills, ready to go, guns out. Eddie, what do you think?
Or their politics, well, I thought that maybe the constituency people would turn against the president or see the president's actions as over the line.
So maybe they're trying to set the president up for unpopular results. Let him implode, right? Lauren, what do you think?
Maybe like they said, like what you're saying. Well, they already ruled on it, so they're just kind of saying like we already took a stand.
Yes, I think this is the right answer.
We already took it. Like what? We're not going to say anything else. We took a stand 5 years ago.
We already did it. I think that's the right answer, right? Why do we need to say anything again if we've already done it? Right? We've already spoken on this. We've spoken on this before it even happened. We said no. As a body, why do we need to do anything again?
How about they don't want to commit another wrong by another wrong because they respect the separation of power? So usually the bill goes from us to the president, but the president makes the law now. So it will be time for the Supreme Court to step in.
Oh.
And respect the separation of power.
So they were basically kicking the issue to the Supreme Court, let the judges deal with it, right?
Yes.
I mean, kind of, because it's like, well, here you have the Taft-Hartley Act in one hand and the executive order in the other.
So Congress spoke, the executive spoke. Who's left? The judges, right? All right. So I think that's good. Let's focus a little bit more on acquiescence, though, right? Let's say, for example, that Congress hadn't passed the 1947 Act. They didn't pass that. But say they passed some general laws saying that, in the event of a labor strike, the president's powers to resolve labor strikes is limited. Let's say the statute just said that the president will need to seek congressional permission to resolve any labor strikes. And then the steel mill happens and Congress stays silent.
They're going to try to stretch that law, that general statement, as long as they can and fall back on it.
Is that acquiescence then? Gwen, what do you think? Is there acquiescence if Congress passed some sort of generic law not speaking its issue and they say nothing? We find acquiescence there.
I think so.
So there's another case I'm going to have you read this year called Noel Canning versus National Labor Relations Board. This was a recess appointments case. And this has what Justice Scalia calls the adverse possession theory of constitutional law. We're learning property. It's funny. In my property evaluations, I get, he teaches so much con law, and he teaches so much property. So for over 200 years, whenever a vacancy arose whenever there was a recess, like someone died or retired, the president appointed people to fill that position, whether or not the person died during the recess. If you read the Constitution very closely and you read the text seriously, the only time that the president can fill a vacancy is if that vacancy arises during the recess. So in other words, Congress goes home for the summer, and then like the Secretary of Agriculture dies during the summer, right? The president can only fill someone if he dies during the recess. But if he dies when Congress is in session, that's not a recess appointment. For over 200 years, the government's basically ignored the text of the Constitution. They've ignored it. And they've made recess appointments all year long. And in a decision last year, it actually split 5-4 on this question. Justice Breyer said, listen, even if this isn't right, it's been going on for so long that Congress has acquiesced to the separation of powers issue, right? The president's been doing this for 200 years, and Congress has been complicit with it. So we're going to uphold it. This is what Justice Frankfurter calls the gloss put in the Constitution. You think like lip gloss, right? It's not the actual Constitution, but it's a layer that's been put on top of it that's been accepted for so many years that's become part of the Constitution itself. Justice Scalia effectively dissented from this and said, wait a minute, there's no adverse possession for executive power. If the executive does something for 100 years and Congress opposes it, that doesn't give him the right to do it. Right? You don't gain a right to an executive power by doing it over and over again. 1,000 wrongs doesn't make a right, so to speak. But this is what's at issue here, right? To what extent does acquiescence dictate? And this is a nice segue into Justice Jackson's opinion. Because Justice Jackson says, listen, we can't resolve this based on clauses of the Constitution, right? We can't resolve this based on, text. We need to look to practice and how things work in the real world. And for those of you who don't know, Justice Jackson was a remarkable man. He served as a Solicitor General for Roosevelt, as the Attorney General for Roosevelt. And then after World War II, he was a prosecutor of the Nazis at the War Crimes Tribunal in Nuremberg. He was an awesome dude. I mean, he took a year off from the Supreme Court to prosecute the Nazis and obtain convictions of the war criminals. A remarkable human being, and a brilliant writer too. His writing is so good. It's a joy to read his writing, because most of the writing is terrible in the court. It's not good. So Jackson says, listen, we can't resolve this based on fixed notions of clauses. Legislative powers granted, executive powers vested, faithfully executed, right? Jackson's entire framework, and we all study these 3 tiers, and we in your Horn book it says you have these 3 tiers, right? But let's try to understand why the 3 tiers are structured the way they are, right? Mike, why is it that in Jackson's first tier, this maximum authority, is the court willing to give such a deference to the executive? What about this first tier makes it so important?
Because he's acting pursuant to an express or implied authority given him by Congress.
And what makes that so significant? Why is that entitled to so much deference?
Because everyone agrees he has the right to do it.
Be more precise. You're on the right track. Talk it out more. It's not in the opinion. Just right here. Yeah. Why is it so significant from a constitutional perspective in terms of this gloss, right? Where both the executive and the legislature are in agreement. Why is that so important? Lacey?
Because Congress represents the people, so it's 100% backing, it's full support.
That's a good answer. Anyone, not quite, but that's a good answer. Anyone else? I think that's right. I don't know if I add to that. When you think in terms of the Constitution, right, we start with the residual of the power, which belongs to the people sovereigns, right? The first 3 words, we the people. Unlike the Articles of Confederation, which were established by the states, remember the delegates from the states, the Constitution was ratified by the people themselves. The states didn't ratify the Constitution, the people did. And the authority flows directly from the people as sovereigns. And by sovereign, I mean the source of authority. So I think as Lacey said correctly, they sent to Washington a president. All 50, well, probably not at this point, 40-something states voted on the president. No other officer in the U.S. has such support. They send members of Congress, House of Representatives. Now they vote on senators. So every facet of the representative country is represented here. Even if there's a violation of the Constitution, which I think there is. I argued 20 minutes ago that I don't think Congress could take this property. Right? I don't think Congress has the power here. But assuming I'm right, assuming that the Constitution does not even permit Congress to seize these steel mills, when everyone agrees, the courts will apply what Jackson calls a presumption of constitutionality. Right? Even if there's a pretty good argument, and I think it's a good argument, that Congress can't even do this, because the entirety of the representative of the American sovereign is behind this, the courts will presume, they'll assume that this act is lawful. They will not step in to interfere. Everyone see that? Any thoughts on that? Okay. This is where the executive acts the strongest. And in virtually every single case, this is what happens. Both houses of Congress pass a bill, and the president signs into law. That is the embodiment of sovereignty. I mean, there's no surprise that our lawmaking process requires all 3 entities to be allowed to participate. If you read INS v. Chadha, you can't have a one-house veto, right? You can't have one house passing laws. Every aspect of our Constitution requires the channels we've met. So when the entire sovereignty of the United States stands firmly behind the decision, in that case, the president can act. I want to see that. All right. So let's talk about Youngstown, the second tier. Let's see. All right, George. George, so the second tier of Youngstown, right? Justice Jackson speaks about the zone of twilight, where it's not really clear what the Congress says. It's not really clear what the president says. So it's really uncertain what can happen here, right? George, tell me, why is it in this realm that the courts should perhaps tread lightly? Why in this realm should the courts not, perhaps not a presumption of constitutionality, but they shouldn't go too hard in this realm? What do you think?
Why shouldn't it go so hard in the realm as far as?
Why should they not be apply such strict scrutiny, if you will? Why in this kind of zone of twilight should the courts be a little bit, uneasy? What about the zone of twilight makes it such a difficult place for the judges to act? You want to take a step?
Is it because they could be limiting themselves in the sense?
Explain that more.
The zone of twilight, it's like the undeclared areas of power, right? So if they act on it by telling them somebody can't do something, then they're essentially backwardly giving them that range, maybe, and that's setting their limit. Kind of.
I'm not sure if I follow. Try one more time. I think you're going to. Yeah, one more time.
I guess they'd rather leave it instead of etching something in stone.
Oh, I
on
see.
it, they would rather just kind of pull back.
And I was going to say that like something similar because each situation might be different and there's circumstances.
Zach?
Yeah, I was going to say based on societal circumstances, it would make sense for the two elected branches to handle the problem and not the judicial branch.
Jason, was your hand up?
Yeah, and just that, the judicial branch has been hesitant traditionally to take on, legislative powers into itself. And so if they act before Congress acts,
Mm-hmm.
the judicial branch acts before Congress acts, then they're essentially setting the standard for what the law would be.
Okay, anyone else want to? Kelsey?
I don't know if I'm reading into this correctly, but if you put too much pressure on one or the other, you might have one side trying to push harder to prove that they have more power.
Okay. I think all of you said the exact right thing. So the next major separation of powers violation here is not between the Congress and the courts. It's not between the Congress and the president. It's between the president and the courts. You often don't think about the courts in terms of the separation of powers. You think that the courts are, there to enforce the separation of powers. But, to quote the Hair Club for Men, right? They're not just an actor, they're also president, right? They are also involved in this struggle. We said this at the outset. For the court to issue an injunction here, right, and say, you cannot seize these steel mills, American boys in Korea may die. There are people on the front line who, if they're, they don't have a new tank because there's no steel, they're going to die. And if you read, there's a declaration from the Secretary of Defense saying, people will die if you do this. And when you have the executive branch telling you people are going to die, that's a very serious accusation. By the way, as an aside, the government usually lies about these kinds of things. So if you were in my Conlaw class, you remember we studied Korematsu, right? This was the Japanese detention case. And the entire basis of the Korematsu and ex parte endo, the entire basis was you had these Defense Department officials who submitted testimony saying, listen, if you let these Japanese people walk around, we have actionable intelligence that they're trying to cause attacks in the United States. The Solicitor General, who's a top lawyer of the government, made this representation to the Supreme Court. They said to the Supreme Court, listen, you have to trust us in this one. If you let these people out, they're going to do bad stuff. There were lies. Even within the Solicitor General's office, they realized that these are lies, and they told them anyway. About 3 or 4 years ago, Neil Katyal, who was then the acting Solicitor General, sent a letter to the Supreme Court, a letter officially saying we withdraw these representations. They were not true. The Solicitor General said, these were not accurate representations. We apologize to the court for lying to you. We take these off the record. And in fact, here's a funnier note. During the Guantanamo litigation, there was serious pressure on the government not to even cite Korematsu because it was based on these lies. And even now, when President Obama does various things, there's pressure on him not to cite Korematsu because of the basis in which it was decided. There's this great expression, during the times of war, the laws fall silent. I could say it in Latin, but I forget. But basically, during times of war, the laws fall silent. So be very skeptical. As a footnote to this, after the injunction was issued, the strike occurred. The strike went on for 50 days. The steel mills had a 50-day strike. There was no appreciable impact in our war efforts. So again, but we don't know this in hindsight, right? What if maybe one of the Japanese Americans had conducted an attack in the United States and blew up the Golden Gate Bridge, right? How do you think the judge would have felt had that happened? Or what if, as a result of the steel strike, there was a shortage of planes and our guys got blown up, right? They couldn't get home in time. So there's a serious separation of powers issue of what the proper role of the courts is, especially in times of war. We saw in Korematsu, the court did not want to get involved with this. They let it go. They said, you know what, we're not gonna invalidate, which is clearly unconstitutional. Korematsu was one of only 2 cases where something actually satisfied strict scrutiny. It was that and the affirmative action cases from Michigan. You know, the most important things in the world are detaining Japanese people and affirmative action priorities. So as a judge, you have to think, is this my role to invalidate this action? The vote was 6-3, right? 6-3. It wasn't even unanimous. And there were 3 judges in a dissent. So what did the dissent say? Wait, Ian, what did the dissent say?
That it was just, they kind of echoed that it was a time of war and that steel was important.
Yeah, the dissent didn't really engage the issues, if you notice, right? The dissent basically said, listen, this is serious business, right? People are going to die if we rule this way. People are going to die. We can't stand for that. So there's a very strong tension here between the executive branch and the courts. Should the courts get involved? I mean, the case which which all of you seem to hate, which I'm going to maybe talk about a little bit more now, is Marbury. Right? Let's talk about Marbury for a minute. I told it last Tuesday. What was the issue in Marbury? At heart, President Jefferson refused to deliver the commissions that were signed out by President Adams. Remember the midnight appointees. So President Adams signed off all these midnight judges, and then John Marshall, because he was lazy, didn't deliver them in time. And then the administration changed. Jefferson refused to do it. Let's assume for a moment that the court had jurisdiction, right? John Marshall held that Marbury had a right to the commission and that there was a duty to deliver the commission. Now, we all know that there was no jurisdiction because the Section 17 of the Judiciary Act of 1789 was unconstitutional. The Supreme Court cannot issue mandamus in its original jurisdiction. So you know that. Let's pretend they had jurisdiction. Would John Marshall have issued an order telling President Jefferson to deliver the commission to Marbury? What do you think? You're shaking your head, Chris. No. Why is the answer no?
Because President Jefferson just refused to do it.
He would have ignored it. If John Marshall had ordered Jefferson to give the commission to William Marbury, Jefferson would have said, that's nice. What? No. He wouldn't have done it. So here we see the tension between the executive and the courts. What would have happened here, right? What would have happened here if the Supreme Court said to Truman, let the steel mill go? And Truman said, no. What would have happened?
Nothing. I don't think there would be.
Whoa, no, something would have happened. What would have happened if the president declined to agree with the Supreme Court? The Supreme Court said, let the steel mill go. The president said, I can't do it.
I think the president still would have done it. I don't know what the.
Don't fight the hypo. The president said, no, I am not going to relinquish control of the steel mill. Zach. Throw the president in jail, really? So would Robert Jackson himself go there and grab the president, throw him in jail? I mean, totally serious.
The Supreme Court Police Department would have shown up on his doorstep and enforced their opinion.
Colin?
No, I was laughing.
Why were you laughing? You're right to laugh. Why are you laughing? It's a fair point.
I mean, and then I guess you would say unscholarly way, it seems silly to say that he would be held in contempt of court.
Yes. Has the president ever ignored the Supreme Court? Well, I can think of a couple. Give me one. Come on, we're in Texas. You guys have to know this. Lincoln? Lincoln. You may recall that during the Civil War, President Lincoln suspended the writ of habeas corpus. Where in the Constitution is this suspended? It's supposed to be by Congress to suspend it, not the president. Lincoln suspended the writ of habeas corpus. Chief Justice Roger Taney, Mr. Dred Scott himself, issued an order, ex parte Merriman, saying, let this guy go. And what did Lincoln say? No. No. I'll defend Lincoln in a minute. What do you do when the executive declines to respect a court order? I may have mentioned this last week. I think it was in the reading. Let's talk about a case like Cooper v. Aaron. Ever know that case? Anyone from Little Rock? Or ever been to Little Rock High School? In Little Rock, Arkansas, Central High School, there was orders from after Brown v. Board of Education that they had to desegregate the high school. The governor of Arkansas stood in the door with his National Guards and said, we will not admit these black students to the school. He told the federal court, you don't get to decide what the Constitution means. I do. You're laughing. Is he necessarily wrong? Is there anything in this book that says the courts are the final deciders of what constitutional law is? Is there anything in here that says that? You want to take a stab? I know you didn't like Marbury. You want to take a stab? Is there anything in the Constitution that says courts are the final deciders of what constitutional means? Anyone? What do you think? Let's see. PJ, what do you think? Is there anything in the Constitution that says the courts are the final people to decide what the Constitution means?
I don't think there is. Trying to remember. Like a true question. Isn't that kind of the point of Marbury?
Yes. Hugo?
Article 3, Section 2.
What does it say?
To controversies to which the United States shall be a party to controversies between two or more states, between state and citizens of another state, between citizens between citizens of the same state claiming lands for the grants of different states, and between states of citizens thereof.
Well, that defines a jurisdiction. But does that say that the Supreme Court is a final expositor? Why can't President Lincoln decide what the Constitution means? Jason?
Well, if there was a clause in here, then nobody would know Marbury versus Madison.
Well, what clause does Marshall cite? Which it's unfair to ask you to read this. Marshall cites a clause. He says the judges take an oath to the Constitution. And how could a judge follow his oath if he's acting unconstitutionally? In other words, the judges swear to uphold the Constitution. If there is some practice they know is unconstitutional, it would violate their oath to uphold the law. So in order to follow through on their oath, they have to invalidate laws. This is basically Marshall's reasoning. Jason, you're wincing.
Well, that's illogical because then review is unnecessary because the president also takes an oath to faithfully execute. And if he's going to follow his oath, then there's no need to review.
And this was Lincoln's argument, right? And I'm going to defend Lincoln, which I usually don't like doing. But Lincoln's argument was he was defending the Constitution. right? He had his own vision of what the Constitution required. He was doing it. Some of you may agree or disagree, but Lincoln was interpreting the Constitution for himself. The governor of Arkansas thought he was interpreting the Constitution for himself. President Truman thought he was interpreting the Constitution for himself. Why is President Truman wrong? Why is the governor of Arkansas wrong? Why is President Lincoln wrong? Marbury? Could that be the right answer? Could the Supreme Court be the body that establishes its own discretion to decide the law? So in a sense, right, it's not entirely crazy for Truman to have said, listen, as commander-in-chief, I think my constitutional powers extends to taking this mill. Why should a court disagree with that? Eddie, what do you think? Why can't the president decide what the Constitution means for himself? Why is it that the judges who are not elected, they're not accountable, why should they be making these calls? Why can't the president decide? It's just what? What do you mean dangerous?
Keep going back to our origins. Dictatorship or a king or monarchy or interpreting it for themselves.
But why is it better for courts to do it? Lacey, I agree there's dictatorships are bad, but why should the courts be the ones who have the final say in the Constitution?
Well, it's a checks and balances. Congress passes laws and then the president approves it. And then if either of it's opposed, then obviously the judicial branch is going to look at it. But if the president said something, there hasn't been a balance between everything. So that would be the highest power to regulate.
But what about in this case, Lacey, where the president took action and Congress said nothing? Why should the court say something? If not even Congress was willing to stop them, why should the judges stop them?
I suppose if Congress wanted to say something once it got to that level, they would.
But they didn't. We know they didn't.
Yeah.
So this is the issue, right? If we think that power comes from the sovereignty of the people, and the people elected the president, he says this is constitutional. Congress stays out of it. Why should the courts be involved then? This is a much better judicial review question than people give credit for. What do you think, Zach? Why should the president be responsible for this? Why can't the president just decide himself? Why do the courts have to interject themselves here?
I think it's kind of founded on the ideas and some of the things we saw in the arguments for the Federalists that people, in fact, when they get in a position of power, they are flawed and they have vulnerable to extending their power beyond the reach of what is fair and right.
So shouldn't the 435 members of Congress be also able to check that? If Congress said no, that would bring us into the third tier, which we'll discuss in a minute, right? But they didn't say anything. Why should the courts, when you're in this nebulous neither region?
Is it an issue of a greater possibility for an informed neutrality?
Oh, okay. Explain.
They're
Think of Federal 78.
They're trained and they're knowledgeable about
And
the law.
what about judges make them special? What did Hamilton say in Federal 78?
Excuse me?
What did Hamilton say in Federal 78? Why are judges unique in our system of government? What attribute of their position?
Because of their I would say knowledge, but training.
Kelsey?
They don't have like a personal interest in it,
What do they have?
a life.
Yes.
life
Life tenure. So perhaps one of the reasons, and again, I didn't sign this, but Marshall discusses in Marbury, is that they're given life tenure for this reason, so they can detach themselves and be independent from these issues. By the way, there's no requirement that judges be learned in the law. In fact, the Solicitor General of the United States, who's a top lawyer of the government, argues for the Supreme Court. He's the only person in the government whose title says he has to be learned in the law. It's the only position. That's actually the quote from the statute. To be learned in the law. Judges don't have to be any. You don't have to be even a lawyer to be a judge. No requirement. We make a very good judge, but you have to be a lawyer. Robert Jackson never graduated from law school either. I think he went for 1 or 2 years and he was an apprentice. Really smart guy.
So me and Justice Jackson might have something in common after all.
After this class, if you'll make it through, perhaps. right? So we don't have a solid footing of why the court should be involved in the second tier, right? If it's the first tier, yeah, let the courts uphold it, whatever, or provide a presumption of constitutionality. If it's a second tier, why can't the Democratic branch work it out? Why can't Congress defund the president, right? Why can't Congress simply take steps to express their disapproval of the president? Why can't Congress impeach? Hold an impeachment trial. I think that'll bring the president's feet to the fire. Okay, that your thought?
You mentioned something about the inaction equal action.
Ooh, okay.
So very much go in line with the acquiescence.
Acquiescence.
Yes.
Good. So if Congress is acquiesced, then they've effectively agreed with the president. They've endorsed him. They've ratified him. All right. Let's move on to the third zone of Youngstown. Right, Gwen. What's the reason why in this third tier of Youngstown the court is so skeptical, is applying such a strict scrutiny to the power of the government? What about this third tier makes it so dangerous?
Because the president's basically going against Congress, what they have already said.
Specifically, put in terms of sovereignty and the people, what about this makes it such a dangerous proposition? Why is it so dangerous when the president goes against Congress? What's he really doing?
Going against the people?
Yes. What makes the third tier so dangerous isn't just the president's making laws, right? Jackson doesn't see it like that. It's the president's going against the will of the people as expressed in their representatives. When you send someone to Washington to meet the representative, you're basically sending them to pass laws. Right, and this poses significant difficulties, and the president disregards this power. But more so, the president's not just going against the people. Who else is he going against? Congress, right? So he doesn't even have respect for his own branches. So here, right, Ian, here, why is there a stronger case for the courts to get involved?
Because in this case, Congress already has the power to take and with just compensation. So if the president's power would, it's not even congruent, I guess it would just conflict with Congress.
Lacey, is your hand up?
Yeah, it flips the constitutionality. I can't say that word presumption. It's flipped completely.
Right. So instead of having presumption of constitutionality, we have what might be called a presumption of liberty. Professor Randy Barnett, who's a mentor of mine, has written a book called The Presumption of Liberty, right? So effectively, who has the burden here? Well, in the first tier, when you have a presumption of constitutionality, who has the burden?
And the first one is supported the challengers.
The challengers, right? The steel mill owners have this burden, and it's a high burden. They have to basically prove that their injury is so compelling that the government should lose, right? But PJ, in this last tier, right, where's the presumption? Who has this burden in the third tier? Who has to defend their actions?
The president.
The government, yes, the president, exactly. This is a rare situation. Usually the government comes in saying, I don't have a burden, it's your burden to prove it. But when you apply this presumption of liberty, the government has to justify their actions. And I'll give you a little tip. If you ever do any constitutional litigation, which I hope you do at some point, the party with the burden loses. This is almost always true. If you have the burden of proof in a case of constitutional litigation, you will lose. You will lose. So by shifting the burden, by Jackson shifting the burden in this third tier, right? This is Justice Jackson, or that's Justice Clark. There's Robert Jackson, right? By shifting the burden in this third tier, you're basically giving the government something they can't win. It's a case they cannot win. So in effect, the three tiers of Youngstown, which I'm sure you all studied and memorized and thought about as this mechanical thing, has very deep resonance with all branches of government. Okay, any more questions on the Youngstown? I want to read a little bit from Justice Jackson's concurring opinion, which, by the way, although it's only concurring opinion, it's been treated as the dispositive holding. So I'll tell you something cool. Guess who was Robert Jackson's law clerk in 1952? A young pup named William Rehnquist. The future Chief Justice of the United States was clerking for Robert Jackson. Now, what's kind of not nice about this is Rehnquist didn't like Jackson, and he wrote very critically of him. One other bit, Rehnquist wrote a memo to Jackson saying that Brown versus Board of Education should rule in favor of segregation. That came to haunt him later in life. But so William Rehnquist was a clerk of Robert Jackson. Okay. The next time the court applied the Youngstown framework, you remember, it was a case called Daines and Moore versus Reagan. This was the Iranian hostage crisis case. And William Rehnquist wrote that opinion. Do you know who was William Rehnquist's clerk that year? John G. Roberts. Chief Justice Roberts clerked for William Rehnquist the year Daines and Moore was decided. William Rehnquist clerked for Robert Jackson the year Youngstown was decided. That's creepy. I can never get past that whenever I think about it. It's really bizarre. And I'm sure there'll be some Roberts clerk who wrote a Guantanamo opinion one day who'll be a justice. Anyway. So let me read a little bit from Jackson's opinion. Okay? With all its defects, delays, is towards the very end. With all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government, except that the executive be under the law, and that the law be made by parliamentary deliberations. Okay, and this last part's my favorite. Remember, Jackson had just finished prosecuting all these Nazis at Nuremberg. He witnessed how Germany went from a republic to a tyrannical state of the worst imagination could happen. He saw how Hitler rose to power through the suspension of the laws, that they passed a temporary law restricting this right and a temporary law restricting this right. He witnessed how the Germans gave up their powers one after another after another. If I had to guess, he was mad at Congress, right? Why is Jackson mad at Congress? Because they gave up their powers. They didn't declare war. They let the president go to war without a declaration, right? They didn't take any steps when the president seized these steel mills. For Congress, it's too easy to be lazy. It's so easy to just give up your power to the executive. If you study the non-delegation doctrine in the Schechter-Poultry case in your Conlaw class, you remember this. So Jackson says, listen, if Congress wants to roll over and play dead while the president runs over our Constitution, I'm not going to let that happen. So this quote's my favorite. Such institutions may be destined to pass away, but it is the duty of the court to be last, not first, to give them up. In other words, if Congress wants to give up their power, fine. But the court, we're independent. We're going to be the last, not the first to roll over. I get the chills when I read that one. Jackson saying, listen, Congress, you guys messed up. You let them have an undeclared war. You let the executive do all those things. And with respect to acquiescence, this will set a precedent for future presidents to grow and grow and grow. And every time the president does not check it, that power will expand. And Jackson says, listen, I realize this decision is important, but we're not going to take this lying down. Done. It's a remarkable opinion, and I still think the most important opinion of the 20th century. People say Roe v. Wade or whatever. No, this defined the executive, right? And remarkably, as I said before, Truman listened minutes after the Supreme Court decision came out. By the way, the timeline of this case is crazy. The entire case went start to finish in basically a month. The Supreme Court resolved this case in about 2 weeks. Jackson wrote this opinion in about 10 days. And actually go to the Library of Congress. I went there recently. You have the drafts of his opinion. And you see the different scratches and lineations he was making. I mean, William Rehnquist was his clerk. So in the aftermath of the case, Justice Black, who wrote the majority opinion, invited Truman over. And Truman said, quote, Hugo, I don't care much for your law, but by golly, this bourbon's good. So even after you had this huge separation of powers crisis, you still had the president having some bourbon with the executive. No one was shot. No judges were removed. There were no impeachment proceedings. Life goes on. And this is a theme which I want to go to again and again in this class. every single instance where the Supreme Court made a ruling, there was no blood in the streets. There was no coup. Go look at any country, right? When the president dies, there's always a violent overthrow and this junta and that junta trying to take power. In this country, we had a case not too long ago called Bush v. Gore. As a result of Bush v. Gore, a presidential election was severely impacted. As an aside, Bush would have won anyway. He had more votes, but pretending perhaps he didn't, right? The Supreme Court stopped recounts that were selective. What did Al Gore? Did Al Gore call up the militia and try and storm Florida and make them count the votes? He went to the courts. Al Gore brought the case to the courts. And the Florida courts ruled for him, and the Supreme Court ruled against him. And then afterwards, Al Gore said, you know what? I don't like this, but I'm going to accept the ruling of the court. Why? Because the rule of law matters more than any one decision, right? The reason why Truman went and had brandy or bourbon with Justice Black was because he recognized how important the courts are to have an independent institution to check the executive. Because even if you don't agree with them today, at some point in the future you will. But once the courts relinquish that role, they don't get it back. In my humble opinion, Congress has relinquished so much power that only now they're realizing the dangers of this. And we'll talk about this later in the semester. When Congress gives so much power to the executive, and it's like, oh crap, what do we do? We got to sue, we got to do this, we got to do that, to fund this, to fund that. I think a lot of the problems we have in government today have come to a head because of this multi-generational succession of power. And it's coming to a forceful head now. Ain't getting better. Okay? So any more questions on Youngstown? All right, let's talk about McCulloch. Most people don't think about this case as separation of powers case, but it is, big time. So Youngstown is what we might call horizontal federalism, right? It's between the executive and the Congress and the court. So all the federal branches. But McCulloch is what we may call a vertical federalism case because it represents struggles between the between the federal government and the states. Between the federal government and the states, right? So let's see. Jason, how is McCulloch? What are the separation of powers dynamics that play in McCulloch?
Well, it's between the state and the federal government, and whether the state has the authority or the ability to impose taxes on the federal government.
Mm-hmm.
So in a sense, and of course, you know, power to tax is the power to kill, and so if a state has the authority to tax federal institutions that are on its soil, then essentially the state becomes superior to the federal government, and that obviously can't be.
Okay, good. McCulloch was one of these cases that if it turned out the other way, would have probably led to a civil war 30 years earlier. So the facts of this case, which I'm sure you all read last year, was that the United States chartered a bank, not like Bank of America, which apparently sponsored this room. I didn't even know that. If you check the little plaque, it says Bank of America outside. Fitting. But it was the Bank of the United States.
You should write second Bank.
Or third, actually. I have an account with Bank of America. I feel like a traitor. So the second Bank of the United States was chartered, right? This raises two very important constitutional issues. First, does Congress have the power to establish a bank? The second issue is, can a state impose a tax on this federal bank? Right? So the first question is one of enumerated powers. Right? It's a question of enumerated powers. Can Congress do this? And often people don't understand why enumerated powers is a separation of power issue in terms of federalism. Right? Chris, why is the doctrine of enumerated powers that Congress can only do certain things? Why is that a federalism issue? More.
Where it's basically all powers that not in the Constitution are reserved to states.
Okay, look, turn to page 45, right? Let's actually read it. It's not that long. Okay? 10th Amendment says, the powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. So let's think about this very clearly. The power is not delegated to the United States by the Constitution. So Chris, under the Constitution, what power is delegated to the United States?
You're talking about for Congress?
Yeah.
That'd be Article 1.
Section? It's on page 23. Fold this page now, we'll be going back to a lot.
Section 8.
Article 1, Section 8. Article 1, Section 8 lists about 16 or 17 different grants of power. And let's think in terms of sovereignty of the people, right? Whatever powers are not given to the federal government are reserved to the people, right? What happens as more powers are given to the federal government? What happens as more powers are given to the federal government? What does that leave with the people?
Less power from the people.
Exactly. So think in terms of a balloon, right? If you squeeze one part of the balloon, the other part gets bigger. When the federal government grows in power, the powers of the state and the people themselves shrink. As the size of the federal government grows, by a necessary implication of the 10th Amendment, the powers and rights reserved to the people have to shrink. You only have a finite number of powers. The Constitution is not a general power, it's specific enumerated powers. So as the central government gets stronger, the powers of the states shrink. Right? Let's take the example of making a bank. Right? What happens if Congress decides to make a bank? That's one less thing the states can do. And let's think about this, right? If Maryland has a law saying that any financial institution in this state must comply with our laws because we determine that's best for our people, by Congress chartering a bank, that statute of Maryland just became unconstitutional because it's a federal bank and they don't have to comply with it, or so says Marshall. So the police power of the state gets contracted, it gets shrunk. Right? What's another aspect? Let's see. Mike, what's another reason why when the power of the federal government expands, it impacts individuals? Think that through. What happens as the federal government can do more stuff to people? Okay, let's see where I'm going with this. Eddie, what do you think? When the federal government can do more stuff to people. What?
Like a can of worms.
What's a can of worms?
Like, I mean, once they can do one thing, then it's like, they're just gonna keep testing it.
What? I'm looking for one word. What does it impact about people? Freedom. Liberty. Right? As the federal government can do more stuff to people, the liberties are shrunk. And let's approach this very, very clearly. We use a contemporary example, marijuana, right? I've never smoked pot. I have no desire to smoke it, but a lot of people do like it, perhaps in this room. I won't ask. Yeah, you need a bar application. I don't want to know. But say, for example, a state wants to legalize marijuana. Let's say you're in Colorado or Washington. And the federal government says, no, it's a controlled substance. You can't do it. The freedom of the people to decide what they want based on their own state's laws are limited. If the state wants you to smoke pot and says you can do it, federal government says no. So as the scope of the federal government's power increases, there's less room for freedom. Randy Barnett uses this great metaphor. Our Constitution is supposed to be this sea of liberty with these little islands of government dotted between. But today it's become the exact opposite, where we have this sea of government with these little islands of liberty we can hop between. Right? It's the exact opposite. So the image is basically that as the size of the government grows, there's less room for individuals to express autonomy, free will, freedom, whatever you want to call it. And one specific aspect, right? Let's say Texas or Maryland or Virginia or New Hampshire passes a law banning marijuana. What happens if people don't like that law? If they don't like the law, what do they do? Yeah.
Well, they can vote. They can vote new people in who can.
Is it easier to change a state law or a national law? Why is it easier to pass a state law?
Yeah, there's less interest involved.
And the people in government are responsive to local interests, right? When you have, I mean, the Texas legislature, I was just in Austin yesterday for the inauguration. When you have the Texas legislature, you know your member of your state legislature. He's local. He probably represents like a few hundred people, perhaps, right? A few thousand, maybe Texas, a few thousand. But depending on the state, it's a lot easier to pass laws when they're responsive. But when you have a Congress in Washington, they're not very responsive because you have to deal with the interests of Texas and of New Hampshire and of Vermont and of Florida. People have very wide-ranging interests. So rather than having a government that's reflexive and responsive to the people of the local interests, you have a national government that is steamrolled by whatever national interests there are. And all the veto gates that go through it make it very hard to change federal law. So in every sense, as the size of the federal government grows, right, there's less room for the states to actually enact laws to the preferences of their people. So in this sense, the doctrine of enumerated powers is a serious crimp on federalism. Because every time the federal government says we can do this, and they pass a nationwide law, they're actually taking away from the local governments their power to decide for themselves what to do. Now, in certain cases, perhaps the states are trying to violate constitutional rights, which we have a different story. So say the states are trying to, pass segregated schools or segregated water fountains, or they're trying to, deny certain rights to people based on religion or whatever it's going to be. Well, in that case, I think Congress may have a very strong role. But we're talking about things like maybe marijuana or various labor things or various local government issues. The government's intrusion actually has what are called federalism costs. If you read the Voting Rights Act cases, they speak of these federalism costs, that when the federal government intrudes on local matters, they're actually hurting the states, inflicting injuries. Okay? All right. Any questions on that? What else? What else about McCulloch implicates federalism and separation of powers? What other ideas you have? What about the fact that you had a state officer walk into a bank and give a tax bill to a federal officer? Right? What's the problem there? What's the problem there?
Who would enforce this if one side refused to participate?
Are you gonna? Well, could the state throw this clerk into jail? If the clerk refuses to pay the bill, could the state throw him in jail? Oh, they could have. He's lucky he didn't wind up in jail. This was a test case, if you will. This was a case brought to try and test this law. But let's look at this issue in reverse, right? What would happen? Oh, Jason, I'll ask this one to you, right? Jason, what happens if, the Texas legislature, they're in session now, they start passing all these new taxes? They impose an income tax. What do you think would happen to them?
If the Texas state legislature passed an income tax,
Yeah.
we'd have a new Texas state legislature the next session.
Yes. I think it would all be all the bums would be thrown out, right? So one of the aspects of having government responsive to the people is that if the representatives do something dumb, they get thrown out. Now let me ask you another question, Jason. What happens if Maryland legislature passes a tax on the federal government? Will they get thrown out for that reason?
No, they would probably be cheered and lifted up. And
why would they be cheered? Who's bearing the cost of that?
Right, it's the other states, the other
Yes.
citizens outside the borders.
Right, and that's the problem, right? You see it. It's the exact opposite issue. When the states start taxing the federal government, the cost is spread nationwide. So it's not like they're just taxing their own people. They're taxing the other 49 states. And the people in New York and New Jersey whose tax bill just went up are not going to be happy with it. So what do you think they're going to do? They're going to start taxing the federal government. And then every state will start taxing the federal government. It'll create basically anarchy. So I think this aspect of Marshall's opinion has to be correct, right? That you can't have states taxing the national government. This is actually, Lauren?
Oh, no.
This is actually a real issue I looked into. I didn't even know the history of this. What happens if you have a post office, right, in Harris County? Are they required to pay property taxes? Can Harris County, and I'm sure if you own a home, you pay property taxes, right? Can Harris County impose property taxes on the federal government? So there's actually one line in McCullough where Marshall says they can charge property taxes. But as a matter of course, the federal government is not required to pay them, but they pay them optionally. It's actually this weird thing. It's called payments in lieu of taxes pilot, where the federal government actually pays money to the state government and local governments just so they don't feel left out. But there's a lot of things that actually come up. So say, for example, there's a military base, in a state, and say the age of consent for purpose of the military is, I don't know, 18. And say in that state, the age of consent is 17. Okay, what happens if there's sex with a 17-year-old? Let's do it the other way around, right? Let's say you're in a state that has banned the death penalty. There's actually a real issue. So you're in Michigan, right, which banned the death penalty. But you commit the murder on a military base inside of Michigan. Can you be executed in a state that does not allow the death penalty? The answer is yes. That's what the courts have held. I think that's probably right. So you can think of, or another one, right? Say you're in a military base in a state that the drinking age is 22, right? And you're 21. And you drink. So there are a lot of really kind of funky issues when you think about it, where federal entities are in states and they have to generally comply with the law. But McCullough is always lingering in the background where if there's too much. Yeah.
Easy one in Texas is concealed carry.
Oh.
You can take it almost anywhere, but don't take it on federal property because the rules are different.
So if you ever go to Washington, D.C. with a gun, which I would not recommend, although safety, whatever. In Virginia, you have a concealed carry permit, you can basically carry wherever you want. The George Washington Parkway, which is a road in Virginia, is a federal park. And there's actually a big Second Amendment case about this, where a guy basically pulled over on the GW Parkway, took a nap, and they arrested him for having a gun, even though he has lawfully to carry it in Virginia. This issue comes up a lot. All right. One other issue to think about, right? What would happen? Let's say this will be the last question for today on this case. What would happen if there were two competing interpretations, necessary and proper, right? So Marshall and Hamilton said necessary means convenient, right? Congress do anything that's convenient to executing a power. James Madison, who wrote the Constitution, said it means absolutely strictly necessary, right? What would our country look like if Madison had won out? That Congress only had the power to do only that which was in the Constitution. Zach, you're shaking your head. How do you think that would have turned out?
It'd be pretty bare bones.
What do you mean?
I mean, like public transportation, all those things like that. Anything that's really imbued upon citizens or required of the citizens beyond what's exactly enumerated would be few and far between.
What do you think would have happened in its place? Would government have just shut down? States. What do you mean?
I think states would have just said, like, if the federal government, the federal government, if they were just, it's strict what the Constitution says, then the states will be completely, totally different. Interstate travel would be hell. Because you'd be going through a state and the rules would be totally different.
I think that's probably right. Jason?
Yeah, you would have this incredible diversity from state to state. So even today, you think corporations are all in Delaware and you have states that specialize in certain things. Vegas or Nevada has special gaming laws. So you do have that now, but in that environment, you would have this really crazy diversity where states would apply their, they would specialize in certain aspects of the economy or rights, or it would just be, it would be a very different picture. And people would be, I think people would be more willing to travel and move and depending on what state they want to be in.
I think kind of like what you said, like you're bringing up these small instances about like drinking on federal property in a state that doesn't, it's like there's like, there's a list, but it's not a long list. But like, could you imagine if all the states had their own rules? I mean, to the point where you can't go to another, like, you're saying you can conceal carry in Virginia. It's like you travel through another state that's, now they're completely off of it. So
Can states reach compacts? So for example, have any of you ever driven out of state?
Yes.
Does your driver's license work in Louisiana? Do you know why it works in Louisiana? Do anyone ever think about this? Anyone know the answer? The Interstate Compacts Clause. So all 50 states have signed a compact approved by Congress, which is we will recognize driver's license from other states. They've also signed them for international law. So if you bring in a license from Great Britain or Canada or Australia, your license will be recognized. The states are actually able to make agreements amongst each other.
There's also something called TALON, which is Texas, Arkansas, Oklahoma,
Louisiana,
New
Nebraska.
Mexico, for that they have an agreement on as far as drunk driving rules and regulations that they apply.
Mhm.
So that's not even all 50. It's just a small collection of geographically situated states.
Right. So it's an interesting thought experiment. We'll do Commerce Clause later in another class, but how would our country have developed in the absence of McCulloch?
Something kind of like Talon, it probably would have been a bunch of states getting together on a certain point, but it would, like he's saying, Talon was for drunk driving. I mean, there may be something else.
There are a lot of coordination costs.
Right.
So there are a lot of transaction costs. It's a lot easier to have a single federal bill than make 50 states agree to stuff. But it's happened. Driver's license, concealed carry permits. Almost 35 states have networks where they respect concealed carry permits from out of state, when the federal government has had nothing to do with it. So any more questions on McCulloch or Youngstown? All right, so let's talk a little bit more about the paper. The reading for this was fairly short. So on February 8th, which is not very far from today, I'd like all of you to have submitted to me a paragraph discussing your paper topic. And a number of you have already talked to me, and I'll probably talk to you more after this class and next week or whenever. But I'd like for you to start thinking about your topic. And one way that might actually help with this is by going through the syllabus and looking at all the different cases we'll be covering. Go through your syllabus from Conlaw1 and look at all the cases you'll be covering. And see if any of these cases jog an interest generally what I'm looking for from you is that you have a topic and you have some sort of thesis. And we talked about this last week, but more precisely, you have to say, here's this case. There's something about this case that's maybe a little bit off, or maybe incomplete, or maybe it doesn't fit in with some other case. Here's why I think the issue should be resolved in this way. Here's my proposed solution. You can say, in light of this case should come out differently, or maybe in light of something else, maybe the court should have resolved it in a different way. Try to think of when you were reading a case in common law or even this class, and you said, wow, man, that didn't make sense. Or what was the court smoking when they read that, right? What were they thinking? How did they possibly reconcile these two decisions? That's law students' favorite. Say, professor, we have these two cases. Can you please make them fit together, right? Can you make a case fit together? Or the court said these two cases fit together. There's no way they fit together. Explain why they don't fit together. The second one's probably a little bit easier, but the first one's a little bit more useful. And the paragraph itself, again, has to be just a couple sentences. Give me the topic, give me what your thesis is, and give me a sense that you know what the solution is going to be. And that's all I'm going to require from you for the February 8th deadline. Okay, so questions? No, unless you have anything else, I will dismiss class, and I see all of you next week. Thank you so much.